One of the things that you're doing is introducing a new Sexual Offences Bill to strengthen the right of victims. What exactly have you got in mind?
So there's been really good work done by my colleague and friend Minister Helen McEntee in relation to taking a zero tolerance approach to domestic, gender-based and sexual violence, and a lot of good stuff that we've started that I'm very determined between now and the summer to get completed.
On the statute books?
On the statute books. So good laws are really important. Getting good laws passed and on the statute books are even more important. So between now and the summer, I intend to pass legislation that will double the maximum sentence for assault causing serious harm from 5 years to 10 years. People will know that one of the most common forms of crime arising from domestic violence is that assault causing serious harm. So doubling the maximum sentence.
So that is even outside the domestic situation, it will apply to all.
It will apply in general for assault causing harm. It just so happens that it can be a major feature of domestic violence. So we'll get that passed, we'll get that enacted by the summer. Also passing and enacting the legislation that will make stalking and strangulation, non-fatal strangulation as it's described, standalone criminal offences. Good work done on this, good work done on a cross-party basis on this. I know Senator Lisa Chambers and others pushed this, worked with Minister McEntee on that, getting that passed. Also passing legislation, which we're nearly there with now, in relation to improving the monitoring of sex offenders in prison, including enabling the courts to electronically tag sex offenders for the first time. I think that's a very important move. And then the other piece that I wish to talk about is the publishing shortly a Sexual Offences Bill. That will do a number of things, but one thing it will do is bring clarity to the whole issue of consent. It's no longer enough, it won't be enough to just believe you had consent. You'll have to demonstrate why you thought you had consent. So a test in relation to that, which I think is important.
One of the most difficult areas to try to enshrine in law. The he said, she said, both people having had drinks or drugs or whatever, and how to disentangle consent, particularly after the fact when, two people wake up and, oh, what have we done and who's done it to whom? And
yeah, but we do have to be very clear that the issue of consent doesn't disappear in any way, shape or form at certain times of the night or after certain social gatherings. And
but when the two witnesses are the two people involved in the he said, she said charges, very difficult.
So what we're trying to do here, and we'll tease through the detail of legally how best to do this in the legislation, but trying to do here is make it very clear that you will have had to take objective steps to actually show that you had consent. In other words, I'd have to be able to demonstrate to you the reasons why I believed I had consent. It's not just enough for you to believe you had consent. You'll have to show me why you thought you had consent. That sounds quite sensible to me. And
but also how impractical. Write it down, dear.
No, I don't. I don't.
Do you know what I mean?
I don't think it's. I'm not suggesting you're being flippant, but I do think it's actually. I do think it's helpful, it's important, it's based on having conversations grounded in practical experiences and based on trying to provide clarity and assistance to the courts. The legislation will also do some other important things around victims' rights. We all know we want more people to come forward in relation to domestic, sexual and gender-based violence, but we need the victims to have confidence in terms of how they will be treated when they come forward. Been a lot of good work done in the last year in making sure every Garda division now has specialist protective units. By the end of this month, they'll all be trained. The next step, I believe, in this legislation has to be about ensuring that the victim's at the centre and protected in the legal process. So at the moment, for example, the victim doesn't often have legal representation. So there's somebody representing the state, there's somebody representing the defendant.
And the victim is a witness.
And the victim is a witness and being cross-examined. So extending the right to legal representation for the victim in certain scenarios will be a very, very important piece. And so also in other words, if
the defence are going hard on the victim as witness, that they will have someone who will pop up in front of the court, I object, or whatever, and appeal to the judge for whatever.
So at the moment, the state is in the room trying to get a conviction for somebody in relation to this. The defendant has a representation, but you as an individual victim, trying to make sure you have that representation as well. So we'll publish that bill very shortly. What I hope I'm trying to convey to your listeners is, in less than a year on since Helen McEntee published the Zero Tolerance Strategy, we're going to see real, concrete, meaningful actions between now and the summer. But of course, if we're to bring around real societal change, it involves much more than just the Department of Justice. Sex ed in schools, how we tackle the misogynistic culture in our country, social media, Andrew Tate, for example, being a big source of conversation. So not down to any one minister or one department, but this is the concrete step. These are the concrete steps we can take.
Now, one of the most contentious things we came across on this programme was the defence in a particular situation having access to the notes from a therapist to the victim. And it seemed to all of us to be unconscionable that should be permitted, but it is.
It is, and obviously within judicial circumstances, which I can't intrude on either. I mean, there is obviously the right to a defence in these cases, and trying to balance all of the different rights.
I mean, you couldn't compel a priest to break the seal of the confessional.
No, and in the Sexual Offences Bill, which will go to pre-legislative scrutiny, we will be fundamentally looking at how do we strengthen the role, the role of and the protection of the victim in the court scenario, so we can tease through all of these issues in that scenario.
Yeah. Now, anonymity to victims, and that seems to me in sexual cases to be hugely important. They can then, if they so choose, waive their anonymity at the end of the case or at any point throughout. Anonymity for alleged perpetrators. Because if someone is vindicated by the courts having been accused, their life may well be ruined, even though, they did nothing that was culpable in law.
Yeah, and look, I suppose you can apply that in general to the criminal justice system. I mean, but being very truthful, if you look at the level of prosecutions in Ireland in relation to these matters and the level of conviction in Ireland, the much larger issue we have is actually managing to bring prosecutions in the first place rather than wrongful prosecutions being brought. So that is where the immediate focus is at. I mean, the actually trying to increase people coming forward in the first instance, coming forward and knowing they'll be believed and supported. Gardaí, DPP bringing prosecutions, and then those prosecutions being successful, and then having robust sentencing in place. So all of the evidence would suggest that the much larger problem is in relation to very low prosecution rates.
But in terms of, if you do have, one person who is much put upon by the system and turns out to be as innocent as the day is long, and I'm thinking of a case of a priest who was accused of sexual abuse, was utterly vindicated, and in fact the man who made the complaint was charged. But that priest was ruined.
Yeah, and there are times when the courts can make orders in relation to anonymity. There are times the courts make orders in relation to what the media can and can't report. And of course, there can be difficult cases that you are highlighting. But like I say, I'm satisfied at the moment that the courts have adequate powers and discretion in relation to that.